Hi friends from around the world. Let us continue with the design issue and design of foodstuffs. And visibility. I have three cases to serve you with, which have to do with visibility issues, a bit one from one angle and another from another angle. So interesting cases, I can promise you. They are quite recent as well. So it is about foodstuffs. Foodstuff, designs is not about what you would usually suspect. Well, it is also about what are the usual suspects, like furniture, like clothing, like fashion accessories, like cars, etc. But foodstuffs also. So you can see this on a daily basis, that leading companies, they try to design some containers or some foodstuff or some packaging or whatever it is, what you find in the supermarket, in order to enhance the attractiveness for the consumer so that they can choose on the basis of the design. So they're spending a lot of money out of it. So it is also, you have a chance that you get this into your practice, and you should know what is the tendency, what is the practice in the European Union. Now, let's dive into the first case. It's about biscuits here on the screen from the General Court of 2014. There was a application for biscuits here on the screen from a company in, I think it was from the Netherlands, and they liked to have this as a design application, a design registration, and it was registered as such. So it shows in reality a broken biscuit, of which in the middle you have some chocolate pouring out. So the chocolate have some fluid substance which are flowing out. So this is the design registration. In 2010, there was a French company, a competitor, so to say, who filed a invalidity claim against this design registration at EU IPO, and they alleged the lack of novelty and lack of individual character. Now, the Cancellation Division rejected the invalidity claim, and it came to the Board of Appeal. The Boards of Appeal inversed the decision, and they allowed the appeal and rejected the design registration. It went further to the General Court, who confirmed the decision of the Boards of Appeal with, yes, they confirmed, they didn't give anything else, so to say, which for educational purposes we should consider here. Now, what was the problem here? If you can see, it was visible, so the chocolate was visible here on the design application, and the design holder argues that, well, in the use of the biscuits on the market, we would see what is the filling of the chocolate, which would give its individual character with regard to the, which is the novelty, so to say, and the individual character for this design. Now, what does the Boards of Appeal say? Well, it says the design registration and design protection, the design law in general, is about the appearance, the overall appearance, the shape of the product. Now, the shape of the product here, of the product as it is sold, not as it is broken into by individual consumers. So the overall product as it is sold by the design holder is a full cookie, right? It's not a broken into the middle cookie. The design holder also says, well, it is marketed like this, so and on designs, on ads and advertisement, it is always shown like this so that the consumer would see that this is something new, something novel, something which has individual character. But the boards of appeal say, well, whether it is marketed like this or marketed like that is not important. The protection has to be done with regard to the design as it is registered. And as it is registered, it must have the full shape of the cookie. So if you see, if you leave out what is the filling of the cookie, so you think the full cookie, it should have been asked for, the design should be represented, so at the moment of the filing, as a full cookie. I don't know why they limited themselves to a broken cookie and why this was admitted. So in order to get the novelty character assessed, it was compared by the boards of appeal with the previous designs on the market, which have been shown before on the screen, and there was not really a different overall impression with regard to those previous cookies on the market. So the round shape, the color was the same, the chocolate was on top, so there was nothing special. The overall impression for the informed user was identical, meaning that the design has been rejected. Well, on my opinion, it could not be in a different way have decided by the boards of appeal and by the general court, because the appearance of the overall product is what counts. There is certain exception for complex products, and they wanted to go a bit in that direction, but you know, it is not a complex product. Okay, let's come to the second case, which is about a round container for food. And it's a decision here on the screen of 2020 from the General Court as well. Here is the design application. You see a round container with a lid on top, and the food is inside. You can see the food, so to say, of that container. And it is closed with a kind of film, transparent film, so you can see what is the foodstuff about, right? It's a container for foodstuff. And this case is about two Latvian companies, so I think there's some fish involved here. Well, whatever, it is packaging for foodstuff, class 9 of the Locarno classification. Against this, again, we have an invalidity claim from another Latvian company this time, and the container of the previous container, so to say, similar container which has been submitted as evidence of lack of novelty, is here displayed on the screen. So it went the same fate as the first decision. So cancellation division rejected the invalidity claim. The boards of appeal reversed the decision, and it came to the General Court. And what was the problem here about? Well, the problem was at the moment of the discussion between the parties whether the content of the container has to be considered with regard to the lack of novelty and the individual character afterwards and the overall impression, right? Well, first, the General Court decision is quite interesting in that case, so you should go through it, because they go through the different concepts of design, and that is for educational purposes somehow good. So they started out with the informed user. What is the informed user? It is not, as you know it from trademark, the average consumer. It is somebody a bit more knowledgeable with regard to designs, what are on the market and what is displayed, what is not. So he has a higher level of knowledge and displays also a higher attention on the different designs. It is not so much, decisive in the cases, but it is different in the argumentation you have to present in Europe in front of the different instances you're in. Now, that is the informed user. The second issue is what is it about the Locarno classification? Well, Locarno classification, such as the Nice classification for trademarks, has administrative purposes. In that case, the boards of appeal, they said, well, it's about packaging of foods. That was the initial claim in class 9 of the design holder. Now, the boards of appeal followed from that, packaging for foods, that this is only about packaging, so that the content could not be taken into account in the comparison of the signs, of the earlier signs, and so in the determination, assessing the novelty of the design. And the General Court rectified this in a sense that, well, this is only for administrative purposes. So you cannot follow from that only the container is to be compared with regard to the earlier sign. But in the end, they agreed with them, because the container is for all kind of foods. So they concluded that the designer didn't want only to present here that food in that container, and they will market that food with that container on as advertisement or whatever. But they said, well, it was about the purpose here was about the packaging, not the food itself. So as the purpose is only for packaging, the food cannot be taken into account. It has been presented only for illustration purposes by the design holder. Now then, it is quite easy. So you have the same dimension and the same proportion, height and rounding. You have the same lid. You have an overall cover which is transparent. You have the same color of the container. So the court agreed with the boards of appeal decision that this is a overall impression which is absolutely identical. So I think here the decision is okay. Well, you have some consequences with regard to your practice. So if you want to make a design application, you have this in mind, that the content is normally not be part of the design protection, and you have to look at the other part, if it is about food, so the packaging, what is on the market without the content. Or you may argue, when you are in the invalidity claimant's position, you may arguing correctly in that sense, not to be fixed too much on the content. There's a third, and the packaging industry, they have to advise the packaging industry in that sense. There's a third decision, which I will not go into specifics. It is from 2019. It doesn't bring very much new on visibility issues. It confirms practically what has been said before. But it is still an interesting case here on the screen. And it involves Ferrero against B&B, a Polish company. And it's about sweet candies and the small container. You have seen them probably on the market, small containers, where the one is transparent without content, and the other has been presented with content. And again, the General Court, they confirmed that the content is for illustration purposes. It may be that other things are inside as well. So it is not a decisive issue what is as a content. presented to the register. So these are visibility issues from a different angle, and I hope it brings you something new.